Calling the case of People State of Michigan versus Michael Boyce. This is file 21-0584SM. Counsel, identify yourself for the record.
Morning, Judge. Benjamin Bragle here on behalf of Mr. Michael Boyce.
All right. Today is the time and date set for bond violation. Mr. Bragle, are you familiar with the bond violation request?
Yes, Judge, I do have the summons regarding it, and I have talked to Mr. Boyce about it at length. We're extremely familiar with what's going on.
All right. What's his intentions regarding the allegations?
Well, quite honestly, Judge, we don't doubt the accuracy of the results of his drug test. However, I believe it's a timing issue on when he was actually put on bond and ordered to abide by terms of bond. So
you think this is kind of a leftover from
before he was put on bond? Yes, Judge.
Okay. Ms. Tidwell?
Yes, Your
Good
Honor.
afternoon. Do we have any other tests from the defendant after this date?
Yes, Your Honor. He's tested a couple times since then, and the tests are negative. He was arranged on 6/7, at which time pretrial services was ordered. So this test did happen after the fact.
Okay, so what Mr. Bragle is indicating that potentially that's still in the system from before the pretrial services, though it still would have been illegal. It just wouldn't have been a violation of bond terms, unless he had a prescription, obviously. So the question I have is, based upon the amounts and your information regarding this, is it plausible that this could have been a use prior to the ordering of the pretrial services?
I do not believe so, Your Honor. In most instances where we have a positive test for methamphetamine, and per the lab, methamphetamine is in a system and out of a system within 24 to 48 hours. So this would fall within that time frame, and the levels are quite high, suggesting that use was closer to when the test occurred as opposed to not.
So, Mr. Bragle, your client has indicated that he doesn't believe he used after he was ordered not to.
That's correct, Judge. As far as arraignment date, I was not his attorney on his arraignment date. So my notes don't indicate the exact date of arraignment. However, upon information and belief, he was arrested on June 6th, arraigned on Monday the 9th, tested on Tuesday the 10th, and it's our contentions that the consumption of the substance was on June 5th.
Okay, let me just take a look here. June 7th at 2:30, it looks like, was the arraignment. All right, how frequent is his current testing, Ms. Tidwell?
I did increase it from the standard to a higher level as a result of this testing and speaking with the defendant and him admitting that there was some issues here going on. Your Honor, I would be recommending that we continue bond regardless of when the use happened, but that we do order that substance abuse specifically be ordered as part of his services. He is involved in counseling services. However, up until this positive test, I don't believe that he was addressing substance abuse issues.
All right. Any objection to that, Mr. Bragle?
Actually, Judge, just to ride on that same thread, he does do bi-weekly mental health. He is working with Midland Psychological Services, and I do believe that he has signed releases so that Midland Psychological can report to the court.
Okay. Well, I think what Ms. Tidwell is saying is our goal is the least a number of services or types of counseling to keep the person. I mean, that's the goal, is the least amount. So it's a domestic violence case. I just don't think that Ms. Tidwell requested anything to do with substances. And so it's not asking him to go to a different counselor. It's just that she may contact them saying, maybe you have some discussions about substance abuse issues as well. And so I'm going to go ahead and add that as a term. He doesn't have to go to anybody else. He's addressing those issues. We just want to make sure that that he's addressing those issues in addition to maybe some self-control circumstances that Midland Psychological. They do a good job. And again, not asking them to do anything different other than just the scope of the counseling. So I'll go ahead and modify it. I understand, Ms. Tidwell, the allegations, and rather than having the defendant making another admission or going to a hearing, if he's just voluntarily willing to make the modifications to the bond, I think that that's an appropriate remedy. So, long-winded way of saying, Mr. Boyce, your counselor may just ask you now about some substances, whereas before we weren't asking them to do that. Does that make sense?
Yes, sir.
All right. So, Ms. Tidwell, I think keep monitoring, and obviously, if this tests again, then we got a bigger problem than what we thought.
Yes, Your Honor. Thank you.
All right. Thank you. Thank you, Mr. Bragle. Thank you, Mr. Boyce.
Thank you, Judge.
Your Honor.
Mr. Burton, good afternoon, sir.
Good afternoon, Your Honor.
Have you had any contact with Mr. Smith recently?
No, Your Honor, I have not.
Okay. I see Ms. Branson has turned her camera on, so I presume, Ms. Branson, this is your pretrial services or case or bond violation?
Yes, Your Honor.
Have you had recent contact with Mr. Smith?
I have not. I have not talked to Mr. Smith since June 9th.
Okay. Well, we're scheduled for 2 o'clock, so I'm going to go ahead and call the case. The People State of Michigan versus Joshua Isaac Smith, file 21-0325 SD. Counsel, identify yourself for the record.
Leland Burton for Mr. Smith.
All right, today's time and date set for bond violation concerns. I will tell you, Mr. Burton, I don't know if you've received it yet, but we did receive a document that was asked to be confidential. The court can't use anything confidentially and utilize that information. So we did pass that information on. It would seem as if your client may have potentially a bigger issue than what would be pointed to. He has failed to sign up for pretrial services as ordered. He has failed to appear. His document was mailed to his home at 3325 Davenport, apartment 251, Saginaw, Michigan, 48602 on or about June 10th, notifying him to be here in person at 2 o'clock. Teresa, do you see, I can take a look. I see no one else in the lobby, no one else walking up to the courthouse. Let me just check screening. I see no one in weapons screening near, well, there is a person near the elevator. Let me see. That looks to be a deputy and another person that is not the defendant. Therefore, I'm going to issue a bench warrant for the defendant because this is a OWI and there's concerns and the information that we received that he might still be drinking and he has other warrants in other areas. I'm going to issue an immediate bench warrant. We'll be adjourned on this case at this time. His bond is revoked. Thank you, Mr. Burton.
Thank you.
I think, Teresa, that's it till 2:30 arraignments.